So
No,
I
how?
need you, we're going to
Because I
end
have
your
questions
hearing,
for the judge?
Mr. Richard.
What are you trying to call it? Incompetent? Is that what you're trying to say I am?
Yes.
I don't understand. What am I meeting with a doctor for? Is there somebody willing to go on the stand and say that I actually committed a crime?
Well,
Who has a claim against me? Like that's what I'm trying to figure out. I'm trying to settle the matter. I'm not arguing the facts.
All right. Today we got another sovereign citizen style courtroom showdown. This defendant was charged with driving without a license, no insurance, and refusing to acknowledge that traffic laws apply to him. Courts across the country have ruled repeatedly. Yes, you need a license to operate a motor vehicle on public roads. Yet, here we are again. And in this hearing, the judge goes a step further. She raises the issue of a competency evaluation. Because when someone fundamentally rejects the legitimacy of the legal system, the court has to determine whether this is defiance or inability to understand proceedings. Let's break it down.
Mr. Richard, are you able to activate your camera?
I can, but I'm moving stuff around at the same time, trying
Okay,
to
well, we can talk.
multitask.
Well, let's just go ahead. I don't know if you were listening in when we were talking about your case. As you know, we've been waiting for the doctors to talk with you to see whether or not you're able to go forward on this matter. And there is now a date set for your interview.
I don't understand. What am I meeting with a doctor for?
They need to ascertain whether you can understand the nature of the charges and whether you're able to assist your attorneys. It's a two-prong
Well,
test. So
I
that's what we've been waiting for.
I understand the nature. I'm trying to figure out the cause. You guys never tell me.
Figure out what?
I understand the nature of this case. I'm trying to figure out the cause of this case. Like, what are we here for?
Well, you've been charged with the criminal offense of driving while your license is suspended in the third degree and operating a vehicle without the required ignition interlock device. Those are the charges.
I've never had a license for you to
So,
suspend.
sir,
I
please
don't know
stop
what that
talking
means.
about the facts of the case. This is your attorney.
Who?
This is Sean Parent, one of your attorneys, so please don't talk about the facts of the case.
Well, I'm not denying any of the facts. I'm just letting you know
Well,
I'm letting you know what I understand is what I'm saying. She asked me if I understand, and I'm trying to answer the question. I'm letting her know what I understand, and I'm trying to figure out what's making me what are you trying to call it? Incompetent? Is that what you're trying to say I am?
Yes, there's legal competency, and it's two prongs, whether you can understand the nature of the charges and whether you're able to assist. So right now, there's a question about whether you are able to proceed, and that's why we're having the doctors talk to you. That's the current
Why
status.
can't I just ask the judge? Like, what
Well,
doesn't the judge know?
I am the judge, and I need those doctors to give me their opinion when they review your records and speak to you, and then we'll get a
Well,
report back. So right now, you're
I never
finally
gave
being
my consent for
interviewed.
that. So I'm trying to get the answers from you. Like I'm in here talking to you.
And I'm
I'm
telling
trying
you that you need to speak to these doctors on April 24th at 9 a.m.
And why do I need to talk to a doctor? I'm still not understanding. Like I'm trying to figure out what.
The hearing starts with the familiar pattern. Why are we here? Who am I? Did I commit a crime? These are hallmark arguments commonly associated with the sovereign citizen movement. The core belief? That the government only has authority over a fictional corporate entity version of a person, not the living human being. The problem is simple. Courts have consistently rejected these arguments as legally invalid. In fact, appellate courts have ruled time and time again that driver's license requirements, insurance mandates, and registration laws are constitutional exercises of state police power. So when someone insists those laws don't apply to them, the judge isn't debating philosophy. She's evaluating whether the defendant understands the charges, understands court authority, can participate rationally in their defense. And that's where competency comes into play.
Because you're charged with the crime, and I need to make sure that you are legally competent to proceed in this matter.
What is the name of the crime?
I told you it's driving while license suspended, third degree, and operating a vehicle without an ignition interlock device.
Is there any injured parties? Is there somebody willing to go on the stand and say that I actually committed a crime? Who has a claim against me? Like that's what I'm trying to figure out. I'm trying to settle the matter. I'm not arguing the facts.
Mhm.
I'm just trying to take care of this and give
And
you
we
guys a
cannot
few hundred.
proceed while your ability to understand the nature of the charges and to assist your
I,
attorneys at issue, we cannot
we're
proceed.
we're
So
wasting
we are
time
in this
because I could
status,
just ask you. That's what I'm
and I'm
saying.
telling you right now, so the next hearing will be hopefully with a report in hand. You will have had your interview on April 24th at 9 a.m. Mr. Parent, you know where he would be going for that?
I'm not sure if it's going to be at the Shoreline Courthouse or at our office in Kent, or possibly at the courthouse in Kent. Kind of depends on where he lives.
You have good contact with Mr. Richard?
Yeah, we have a good phone number for him.
Okay.
So we will be able to keep in touch with him.
Okay, so Mr. Richard, they're going to meet with you on the 24th. And
How
would it take about a week or two, Mr. Parent,
are
do you
they
think
gonna
to get the report
come
back?
meet somewhere or something? Like what are they about to do?
Let's have him return on May 6th.
Well, like I said, you don't have my
Actually,
consent
May
to send
1.
me
Let's
to a
do May
doctor.
1.
So I don't know why you think I have to go see a doctor when I could just ask you all the questions that's stopping us from going forward. I told you I'm trying to settle the matter. I don't know what's going on.
Right. We keep trying to explain that to you, Mr. Richard. The reason is you're going to have to talk to these doctors and we'll get some additional information.
All right,
So
cool.
your
Okay, well,
next hearing will be on May 1st.
has there been a guilty plea that has been put into record?
No, we can't do that because we have to determine whether or not you're able to proceed in this case.
So there is no plea that's been put in filed,
There's a plea of not guilty that's been entered.
and who put that in?
You had a first appearance and you are unable to plead guilty. So a not guilty plea has been entered on your behalf and we are waiting to have the doctors talk to you. And
How
this has
can
been going on for quite some time, Mr. Richard.
how can somebody put a plea in for me? That makes no sense. Doesn't the attorney have to do what I ask them to do, or they're acting in dishonor if
Well,
they don't do what I tell them to do?
all of this confusion that's going on right now is many examples of why we need this evaluation to take place. So
No,
I
how?
need you, we're going to
Because I
end
have
your
questions
hearing,
for the judge?
Mr. Richard.
Then things escalate. The defendant refuses to turn on his camera during a virtual hearing. Now, here's the legal reality. Judges have authority to enforce courtroom decorum, including in remote proceedings. Failure to comply can lead to removal from the hearing, bond modification, or even contempt of court. Contempt isn't about hurt feelings. It's about maintaining order and authority in judicial proceedings. The judge, however, chooses patience over punishment. That's not weakness. Often, judges allow defendants to speak freely because the record becomes clearer that way. If someone is exposing their own lack of legal grounding, there's strategic value in letting that unfold.
I have questions for the judge, and you're just saying that I'm incompetent. Like, why can't I get the answers from you? Do you not know your own laws?
I cannot go forward until I get a report from the doctors.
And why is there a doctor that needs to be involved in this? This is what do you say, a traffic matter?
Okay, I'm going to conclude this hearing. I believe that we need a report from the doctors based upon your answers, and this has been going on for
I
quite
just
some
told you, like,
time.
I'm not denying any of the facts. So why do we need to see a doctor? Can I just pay for can I just settle the fines that you have in
There's
this case?
a
Can I
criminal
just do that
charge
and
with
get this over
jail.
with? Huh?
All right, so
What'd you say?
it's a criminal charge with jail. It's not just paying a fine, Mr. Richard. So we are going to set this over. May 1st will be the next date you come back to court. And I will
Well,
ask that you follow through and attend that evaluation on April 24th.
you just
And
told me
that
this was
Mr.
criminal,
Parent
right?
is going to make sure you know where you need to go.
But you just told me this was criminal, right? So why can't I just settle the fines?
Because criminal is not about fines. It's about jail time as well. So
And why does somebody get jail time for something that they never had? I've never had a driver's license.
Mhm. Okay, so we are done with your case today, Mr. Richard. Thank you. We'll get that date out to you.
Well, you don't have my consent, so like I said. I don't know what you think I'm.
All right.
At first glance, it might seem like he got away with something. He didn't turn on his camera. He challenged authority. And he wasn't immediately jailed for contempt. But here's what really happened. Everything was documented. Every refusal, every argument, every disruption. Judges don't always react instantly. Sometimes they build a record first. And when sanctions come later, they're supported by clear procedural justification. Courtrooms are long games, not viral moments.
Mr. Chris, the allegation is that on or about March 29th, you assaulted Michael Kurth in Three Rivers. It's a misdemeanor punishable by up to 93 days in jail and a fine of up to $500. How do you plead to that charge?
Before I plead, I'd like to have it put on the record that they're, for the alleged actions, they're trying to charge me twice. They're trying to charge me with an assault and battery as well as violating a restraining order for the same actions.
Well, they can do that.
Why?
It's two different things.
But it's the same action. Isn't that double jeopardy?
No. Let's say you have a trespass order and you're not supposed to trespass on a piece of property, and you enter into the property and punch somebody. Well, they can charge you with trespassing and the assault. So I'm assuming you wish to plead not guilty to?
But that's violating two different laws. I supposedly violated with the same action. It wasn't two different things. They're trying to charge me with the same action for two different cases. That's not, I mean.
All right, well, if you want a lawyer, I'll get you one.
Yeah. Yeah, I mean, it wasn't, I didn't do anything anyways, but from what they said, that from the affidavit that they gave me, the action.
Who has the which judge has the restraining order?
Patterson. I have not arraignment. I mean, I guess it'd be a preliminary exam conference tomorrow morning with him. Because they're saying I violated the restraining order by assaulting him.
Okay, well, all right, we'll sort that out. Set attorney pretrial for July 12th, 2024. Mr. Chris owes $1,175 worth of unpaid fines and costs. He has a controlled substance case from 2021 where he owes $175. He has a defective equipment case where he owes $125. He has a previous assault and battery, 221627, where he owes $275. He has disturbing the peace where he got the minimum fine of $125. He hasn't paid that. 222147. And he has a felony resisting and obstructing reduced to a misdemeanor, attempted resisting and obstructing. He owes $475 and he hasn't paid anything on that. So why don't you please take Mr. Christ into custody?
Can we please talk about this?
Yeah, you go back into jail and
I have my vehicle outside and stuff though.
Yeah, okay, you go back here and I'll talk to you in a little bit.
Today?
Yeah, right now. You're going into lockup.
No, are you going to talk to me today?
Yeah. You keep getting charged with assault crimes and then you don't pay any of the fine. I'll talk to you in a little bit.
Okay.
In the second hearing, a different defendant enters loudly invoking double jeopardy. For clarity, the double jeopardy clause of the Fifth Amendment prohibits being tried twice for the same offense. It does not prevent separate charges arising from the same incident, multiple offenses committed during one event, enforcement actions for unpaid fines, trespassing and assault, two separate crimes. Unpaid fines lead in custody, not double jeopardy. The judge denies release because fines were unpaid and obligations ignored. That's compliance enforcement, not constitutional violation. Both hearings highlight a recurring issue: legal terminology without legal understanding, invoking buzzwords like jurisdiction, authority, double jeopardy does not override statute or precedent. The courtroom runs on. Procedure, documentation, compliance, not volume, not internet theories, not confidence alone. Now here's the real question. Should judges shut these arguments down immediately? Or is patience the smarter move? Allowing the record to speak for itself? Let me know your take. Because in court, ideology doesn't control the outcome. The law does. But yeah, I'm going to wrap it up here. Thank you guys so much for watching. Take care, everybody.